Okay, states' obligations to each other. So going back to when they wrote the Constitution, everything, I assume everything, in that Constitution was written by men living under the Articles of Confederation and therefore writing a national government that solves the problems of not having a national government. And again, and I'm very repetitive on this, it was meant to be a small national government, only doing what was necessary that couldn't be done in a state. So, of course, they have a list of Article 1, Section 8, enumerated powers, the list that the national government and only the national government can do. And that list included, for example, coining money because they didn't want all the states to have their own currency. Well, the other issue that came up was how states were treating each other. And they were treating each other, Virginia is going to operate under its own best interest, etc. And they weren't necessarily treating each other the way that would create a better functioning geographical location of states that would be stronger by being united. So they were allowed to squabble with each other and create like mini countries, and they didn't want that. So in the Constitution, they wrote up, the framers, the writers, wrote up what the states could not do to each other because these were problems and they wanted to solve them. Federalism involves more than relationships between the national government and state and local. The states must deal with each other as well. And the Constitution outlines certain obligations that each state has to every other state. First, full faith and credit. Suppose, like millions of other Americans, a person divorces and then remarries. This person purchases a marriage license, which registers the marriage with a state. So you get married in the state of Michigan. And Michigan has marriage laws. And who can't get married and how old you have to be to get married. It's a reserved power for the most part. On the honeymoon, the person travels across the country. Is this person married in each state he or she passes through, even though the marriage license is with only one state? Can the person be arrested for bigamy because the divorce occurred in only one state? So the reserved power of marriage is two components. There's a religious component, which we're not talking about here. We're not talking about marriage as a religion. We're talking about marriage as a legal contract. A contract between two people in a court, in the eyes of the law. It does not have to be religious, and a religious marriage doesn't even have to be legal. But we're talking about a legal contract, and there are rules in every state on how you can do it. And when you get married in one state, you are married in all other states because of full faith and credit. The answer, of course, is that a marriage license and a divorce, like a driver's license and a birth certificate, are valid in all states. Article 4 of the Constitution requires that states give full faith and credit to the public acts, records, and civil judicial proceedings of every other state. Civil judicial would be like lawsuits if you sue someone. This reciprocity, get that word out, is essential to the functioning of society and the economy. That's an opinion. Without the full faith and credit clause, people could avoid their obligations, say, to make payments on automobile loans simply by crossing a state boundary. In addition, because courts can enforce contracts between business firms across the state boundaries, firms incorporated in one state can do business in another. You take this for granted. You take full faith and credit for granted because you live in one country and you understand and know that if you move across to other states, your contracts are still valid. But keep in mind, that wasn't necessarily the case before the U.S. Constitution. So full faith and credit. You can imagine a few years back, before same-sex marriage was deemed constitutional, we had a different plethora of different rules about whether or not a man can be married legally. We're not talking religion here. Can have a legal contract with another man in marriage, or a woman with another woman. And so in one state you would be legally married, in another state you wouldn't be. We can talk about that more in class. Okay, extradition is a good word to know, vocab word there. What about criminal penalties? Almost all criminal law is state law. If someone robs a store, steals a car, commits a murder, the chances are that this person is breaking a state, not a federal law. The Constitution says that states are required to return a person charged with a crime in another state to that state for trial or imprisonment. A legal process called extradition. There is no way to force states to comply, but they usually are happy to do so, not wishing to harbor criminals and hoping that other states will reciprocate. Thus, a lawbreaker cannot avoid punishment by simply escaping to another state. They have to do extradition per the Constitution. All they're saying here is it's on the honor system. A lot of things are on the honor system. States follow it. So you'll hear people say they're fighting extradition from Florida. Doesn't mean really anything. I yet to see where a state would deny another state extradition unless they want to prosecute the person themselves. It's different if you leave the country, though. Then we have to have treaties for extradition. That can be hung up with death penalty, because some countries do not acknowledge or believe that the death penalty is right, morally right, legally right, and so that can hang up if they can in extradition. Okay, privileges and immunities, third one. The most complicated obligation among the states is the requirement that citizens receive all the privileges and immunities of any state in which they happen to be. Remember, if you're immunities, a privilege, you get a privilege, like a driving is a privilege. Immunities, if you're immune to something, you can't get it. You have immunity. The goal of this constitutional provision is to prohibit states from discriminating against citizens of other states. If, for example, a New Yorker visits Florida, the New Yorker will pay the same sales tax and receive the same police protection as residents of Florida. Okay, so the idea is if I go to Ohio, they can't treat me differently because I'm from Michigan. I have the same privileges, same immunities. However, there's lots of exceptions. For example, consider tuition at public universities. If you reside or live in the state in which your university is located, you generally pay a tuition substantially lower than that paid by your fellow students from out of state. Only residents of a state can vote in state elections. States often attempt to pass some of the burdens of financing the state government to those outside the state. For example, through taxes on minerals mined in the state but consumed elsewhere, or special taxes on hotel rooms rented by tourists. The state of Florida is a good example on the special taxes. They have a lot of vacationers. They make a lot of money through tourism, so they don't need to tax their people who live there, their residents, as much as somewhere from the state of Michigan. So if you hear someone argue, oh, they don't have an income tax in Florida, well, that's because they have Disney World. And with Disney World, they can make a lot of money off of people who don't live in Florida. Each state has its own unique circumstances there. But if a person in Florida were to take a hotel room in Florida, they still have to pay the hospitality tax. It's just many of those people paying it are from out of state. The Supreme Court has never clarified just which privileges a state must make available to all Americans, except that the clause only applies to activities that bear on the vitality of the nation as a single entity, as a single nation, as a single country. In general, the most fundamental the right, the less likely it is that a state can discriminate against citizens of another state. Relying on the Privileges and Immunities Clause of the 14th Amendment, which prohibits states from denying the privileges and immunities of citizens of the U.S., in 1999, the Supreme Court held that California could not require a new resident to wait a year before becoming eligible for welfare. So this is an example, privileges and immunities, that if no one's suing, if there's not a lawsuit, or the Supreme Court just kind of ignores it, refuses to take up the case, it's just a patchwork of who knows. Who knows what the issue is? Who knows who would win? We're just going to keep it really vague. And then when a court case comes along, maybe that will change the interpretation for one issue, not the entire clause, but one issue within the clause. So it's just case by case. And you're going to see that's often the case with the Constitution, especially when we get into the Bill of Rights. Okay. I'm going to stop right there on this one just to make it neat and a clear, easy break.